morning, good afternoon, good evening, and welcome. I'm Ahmad Rashad Thompson, and this is the Compliance Sprint. Over the next 3 Tuesdays, we're going to cover the employment compliance requirements that every business in the Bahamas needs to get right. Not the theory, the actual rules. Today is session 1, and we're calling it the paper trail. If your business is based in the Bahamas, if you're running a team, managing a payroll, or handling HR for a Bahamian employer, this session is specifically for you. We're covering the contracts, the records, and documentation that the Employment Act requires you to have in place from the moment someone joins your team. Now, before we get started, Triblock HR has put together a free resource for exactly this, the Bahamian Employers HR and Payroll Compliance Handbook. It covers everything across all 3 sessions. I want you to get it now from the link in the chat because we're going to be using it throughout the course of our day and over the next 3 sessions. Let's go. If you're like me and you've worked in HR for any length of time, you've had a manager storm into your office and declare they want this person fired now. Well, that's always right after the last straw has been broken. At Triblock HR, we've put together all the resources you need in this particular sprint to help you to understand exactly how to deal with just issues like that. Because here's the reality. Most businesses that get into trouble with employment disputes in the Bahamas aren't trying to break the law. They just don't have the paper to prove what was agreed. A dispute comes up, a complaint gets filed, someone needs to show what was in the contract, and there either is no contract or it's missing half of what it needs to say. The Employment Act is clear. Every employee is entitled to a written statement of their terms and conditions of employment. That has to happen before or at the point they start work. Not during probation, not after the first month, at the start. That written statement is your foundation. Everything else we're covering today builds on exactly that. So what does your contract actually need to say? Open the Compliance Handbook to Section 1, Employment Contracts, on page 4, and follow along with me. At minimum, guys, your contract needs to cover at least 9 things. The full legal names of the employer and the employee, the job title and what the role actually involves, the start date, where the work will be performed, the hours, how many per week, and what the schedule looks like, the rate of pay, and how often wages are paid, leave entitlements, whether there's a probationary period, and notice, what's required from both sides when employment ends. The last one I want to come back to, but first, notice periods. So let's keep it real. I want you to understand something. You can't expect an employee to walk into an organization, sign all your formal forms, and still have no idea when they're going to be paid, what time work begins, who their supervisor is, where they should even report to do this work. Your 9 facets of that contract must include these details. Otherwise, you're setting up this employee for failure. You're also setting yourself up for failure as well. Your contract needs to specify what notice is required from both sides when employment ends. If your contract names a period that meets or exceeds the Act, then you're in good standing. Your contract governs that environment. If your contract says nothing, the Employment Act kicks in automatically. The Act's minimums are less than 1 year of service equals 1 week's notice. 1 to 5 years is 2 weeks' notice. 5 or more years, 4 weeks, or 1 month's wage, whichever is greatest. Now, those are the floors. You can offer more if you'd like. The law does not allow you to offer less. Let's talk about probation. This is where a lot of Bahamian businesses get it wrong in both directions. The Employment Act allows for probationary periods, but probation is not a free pass. There are rules, ladies and gentlemen. Typical duration is 3 to 6 months. Don't go have a year-long probation on these people's job, okay? The probationary period must be clearly documented, though, and written in the contract to be legally effective. It can't be assumed or applied retroactively. During probation, you have more flexibility to end employment, but your employee still has rights. They still get paid. They still need to be registered with NIB within 7 days of starting, and we'll cover NIB next in our full session on Tuesday. The mistake I see most, however, is businesses either leave probation out of the contract completely or they use it as a jurisdiction to dismiss someone with no process at all. Neither of them work. Both create unnecessary exposure. If your contract has a probationary clause, use it properly. Set expectations at the start. Conduct a formal written review before or at the end of the period. Provide written confirmation when the employee completes probation. And if you're ending employment during probation, still do it properly and with integrity. The full guidance is in Section 8 of our Compliance Handbook on page 10. Now, so many of us in HR and in business believe that because probationary periods are a grace period for us, we misunderstand what that process actually entails. Your employee is still actively engaged in work while working with you, even when he or she is on probation. Probationary periods do not give you an excuse to act off or to treat this employee poorly. Additionally, if an employee is on probation and that probation needs to be extended, he or she must be made aware in advance of the probation ending that the probation is going to be extended. You must also take due care to ensure that the reasons for that extension are clearly outlined in any writing that you provide to that employee. Employees should not be guessing why they're on probation or why they're not on probation. I hope that's clear. So, the contract is one part. The records you're required to maintain are ongoing. That's the other part. Under the Employment Act, every employer in the Bahamas must keep accurate, current records of hours worked, wages paid, and leave taken for every single employee. You also need to hold a copy of every signed employment contract. NIB registration confirmation for each employee is also required. Written warnings and disciplinary records should also be maintained. Leave balances, annual, sick, and any approved leave. Work permit documentation for any non-Bahamian employees on your team. That last one matters a lot. If you're employing a non-Bahamian national without a valid work permit, your exposure goes well beyond a fine. How long do you keep all of this, you're asking? The Employment Act requires a minimum of 7 years, not from when the employee leaves, 7 years from the date of each record. And here's why this matters practically. When a matter goes to the Department of Labor, your documentation is what your case rests on. If you have the records, you can respond. If you don't, the absence of documentation can be used against you. Run a quick check on where your business stands right now. The HR audit self-assessment covers documentation across 25 items. The link for that is in the chat. Now, let's talk about this 7 years record thing. I know that may seem like a lot. You may be thinking, where am I going to put all of this documentation? That's another reason you need to be digitizing your workforce. But that's another discussion for another day. But could you imagine having to go to court 6 years from now for an event that an employee decided to take up to court now? That employee has the right to do so. What you have the duty to provide is the documents that reflect the decisions you made all those years ago. You have to ensure that the documentation you're keeping on file is accurate, is in good form, and can be presented whenever it needs to. So, here's what we covered today. The Employment Act requires written terms of employment before or at the point someone starts work. Your contract needs to cover 9 things, including the parties, the role, the hours, the pay, leave entitlements, and the notice period. Probation is typically 3 to 6 months and must be in the written contract. Notice periods run from 1 week for under a year of service for up to 4 weeks or 1 month's wage for 5 years or more. Your records must cover hours, wages, leave, NIB, and work permits held for at least 7 years. None of this is complicated. It just has to be done. So, download the Compliance Handbook if you haven't yet. Read Section 1, then run the HR self-audit against what you currently have. Those 2 things together will tell you exactly where you are and where any gaps exist. Session 2 is next week, Tuesday, July 22nd. We're calling it Know the Numbers. We'll go through NIB in full, the rates, the insurable wage ceiling, the filing deadlines, and the payroll calculations your business needs to get it right every single month. If you're running payroll for a Bahamas-based business, your team is in the Bahamas, and you're not fully confident in your NIB numbers, that session is certainly for you. The replay goes out to everyone who registered. So I'll see you next week, Tuesday. Should the Lord tarry. Good evening, everyone. Good morning, good afternoon.